According to that clock, it's 8:30. According to this one, it's still 8:29.
Good, you can round off.
Fair enough. All right. I'd like to call this June 9th, 2026 meeting of the Board of Adjustment to order. I am Board of Adjustment Chairman Steve Heineman. For those of you who have not been with us before, the Board of Adjustment city members are appointed by the City Council. The extraterritorial jurisdiction members, such as myself, are appointed by the County Commissioners. Appeals from the decision of this board may be taken to a superior court. I'd like to begin by asking staff to take roll call to make a determination of quorum. A quorum requires at least 4 members to be present. When called upon, members please respond in affirmative. Ms. Lawson, would you please take the roll?
Sure. Chair Hyman?
Here.
Vice Chair Ireland?
Here.
Member Woods?
Present.
Member Holland? Here. Member Check?
Here.
Member Grant?
Here.
You have a quorum.
All right. Next on the agenda is to approve the minutes from the last meeting of the Board of Adjustment held on May 12th, 2026. Has everyone had a chance to review them? Any changes that anyone would like to make?
Motion to approve.
All right, I need a second.
Second the motion.
Second, all right. All in favor? Aye. Opposed? No? All right. Those minutes are approved. Next on the agenda is the approval of the written decision regarding special use number 26-0001, which was heard at the May 12th, 2026 BOA hearing. Are there any changes to that? No? All right, need a motion to approve?
Motion.
All right, and a second?
I'll second.
All right. All in favor? Aye. Opposed? Very good.
Mr. Chairman, just for the record, I wasn't present at the May 12th hearing, but I just wanted to note that my votes are to reflect the confidence in the process and the notes reflected there.
Thank you. All right, next on the agenda is the Notice of Appeal 26-03. Decision regarding the affirmation, modification, or reversal of the staff decision requires an affirmative vote of the majority of the board. This hearing is a quasi-judicial evidentiary hearing. That means it's like a court hearing. State law sets specific procedures and rules concerning how the board must make its decision. We have our attorney present to assist if there are questions regarding the rules of procedure or other applicable law. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. Participation is limited. This meeting is open to the public. Everyone is welcome to attend. Parties with standing in this case, which involves a legal determination, have rights to participate fully. If any other members care to offer evidence relevant to the specific legal criteria for affirming, modifying, or reversing the decision of the code enforcement officer, they will be permitted to testify. If you will be speaking, please avoid repetition and focus on the facts and specific criteria set out in the city's ordinances, not personal preference or opinion. If the number of speakers is excessive or if testimony becomes repetitive, the chair reserves the right to limit remarks to those having legal standing under the law. All witnesses must be sworn or affirmed before testifying. Do any of the board members have any conflicts of interest for this appeal application? No. A legally impermissible conflict is defined by statute as a substantial family, business, or associational relationship with any party to this hearing. Doesn't look like there are any. So at this time, I call on the planning department to present an overview of the case and formally enter the materials into the record. And before you start, raise your right hand. There you go. Do you solemnly swear or affirm that the testimony you're about to give in this matter shall be the truth?
I do. My name is Jeff McClintock. I'm a principal planner for the city of Burlington. If you'll have patience with me, I'm going to read the staff report, the staff fact sheet into the record. This case is Notice of Appeal 26-03. The property owner, Jason Ross Auto Sales, LLC, The applicant, Travis Kentrell, with Priority One Auto Sales. The request is an appeal of the notice of violation, and the location is 1927 South Church Street, Burlington, North Carolina, 27215. The Alamance County Tax Parcel Identification Number, or PID, P-I-D, 121448. The zoning is general business. Travis Cantrell with Priority One Auto Sales appeals the determination made in a notice of violation issued on May 6th, 2026 by Burlington Code Enforcement Officer Matt Thomas. The NOV was issued for removing the existing signs and replacing with non-conforming wall signs in violation of UDO Section 9.5.D1 and UDO Section 5.6J13. Enclosed, please find the application and supplemental materials. Attachment 1 is the SmartGov application. Attachment 2 is the aerial map. Attachment 3 is the existing zoning. Attachment 4 is the future land use map. Attachment 5 is the notice of violation. Attachment 6, a photograph taken by Code Officer Thomas. Attachment 7, UDO Section 9.5, non-conforming signs. Attachment 8, UDO Section 5.6J13, wall signs. Attachment 9, UDO Section 2.4C, appeal. And today we have Code Officer Matt Thomas here, and he can explain the notice of violation and the circumstances surrounding this violation and answer any questions that you have.
Thank you.
This is my first one, so sorry.
No worries. Please raise your right hand. And do you solemnly swear or affirm that the testimony you're about to give in this matter shall be the truth?
Yes.
All right, please proceed.
The day in question, I drove by the sign while it was down.
Chairman, we have the witness probably should identify himself and give the name and address, if you will.
My name is Matt Thomas. I'm the code enforcement officer in question, sorry.
Thank you.
So
And the address?
it is 1927 South Church Street. So I drove by the property, and I saw that the sign was down. And when I went to the property, I asked him about it and said that it was in code violation, to which he stated that they were just replacing or covering up the sign, and they were going to be putting it back up. It was the same sign that had been taken down before, and they were covering it up, and they were going to be putting it back up. To which I told him I would have to ask my boss about that. So I left, called my boss, Chris Marland, and then he told me it was still in violation, because when you remove a sign, that it becomes in violation because if it's taken down for any reason. And so that was when I issued the notice of violation to them. Okay.
Can I ask a
Yeah.
question? Yeah, sorry. So, in looking at what the person said in they're saying that the sign was not taken down, only the panels. But did you see where the whole sign was taken down?
The sign was taken down. The framing that you attached to was not.
Okay.
So like the bracket was still up, the signage, the sign was not.
All right. So the bracket was still up, but the whole sign was taken down.
Yep.
Question for you. What are the measurements of this sign?
I don't have the exact measurements. Do you have do you know the exact measurements? Okay. I'm not 100% sure.
And so your understanding of the issue at hand here is that they put up a different size sign, non-conforming sign? What's the,
So when you take down a sign in the ordinance that says for any reason, that is, and you put it back up, if it's too large for I don't know the exact measurements, but the signage is clearly too large for the property, for the building itself, for a wall sign. You can tell that from the photo, but I do not have the exact measurements.
and I'm going to pull up the picture from the EDO. Is this the relevant page when it talks about sign size? Is that
Yes,
correct?
sir.
Okay. And what makes this sign too large? Just,
It's supposed to only be either 300 square feet, or the lesser of 300 square feet, or 1.5 times the linear footage of the wall.
linear footage of the wall. Okay. Not the total linear footage, but the linear footage horizontally?
Horizontally,
Okay.
yes, not everything.
Are there any other photos of this? Because I can't see the size of this building in the photo that you've given us here.
That's the width of the building.
Thomas, I've got a question.
Yes, sir.
So the notice letter mentions, non-conforming sign removed for any reason shall only be replaced with a sign that complies with the provisions of the ordinance. So is the idea that the sign was too large originally, but only because it was removed?
Yes, sir.
And then replaced, that it's then in violation?
Yes, sir.
And there's also language in that letter regarding, please obtain a permit for the signage on the building. All new signage must be in compliance with the Burlington UDO. Again, just help me understand. So is the notion, following the removal of the sign, in your opinion, there should have been an application or permit for a new sign to,
Yes, sir.
or even if it's
Yes,
reportedly replaced or repaired,
Yes, sir.
that a new permit should have been obtained? Okay.
that's correct.
So you were aware that, was it Jason Auto, the previous, Jason Ross Auto Sales had a sign that was not compliant?
That is
before?
correct.
Okay.
Yes.
And was it grandfathered in? Had they been fined? What was the story
No,
on that?
They were grandfathered in. They had not changed it since before the UDO was put in place. Yep.
Just for, just to the extent that you can opine, I'm not sure. You describe brackets remaining. The applicants, in his documentation for this meeting, they describe removing the panel. I'm just curious, I don't know the sign lingo. Is there a distinction between brackets and panel? And if that's not relevant, then, I'm
So-
just curious.
The way the sign looked to be set up was there was a bracket across the bottom, bracket across the top, and then you had the sign that you would place on those brackets. That was the determination that was made.
Gotcha. And another quick question. I've driven by the property. I mean, are there signs on each side of the building and maybe on the front as well
Yes.
from the street view?
Yes.
And again, just for clarity's sake, is this, are we discussing one of those
The
three
sign.
signs?
The front-facing sign.
Okay, the price in the road.
And the other two are in compliance?
No, that was not in question at the time. Put it that way.
Any other questions from the board at this time?
Right. So what you're saying, or what they're saying is the panel, is the sign itself, is the panel.
Yes, ma'am.
Is that right?
Yes, ma'am.
and it's just like the TV bracket.
Mhm.
We took the TV off and the bracket remained.
Yes, ma'am. That's a good way of putting it.
Yeah.
So was the sign that was removed and the sign that it was replaced with the same size?
Yes, it's the same sign.
Okay.
So he covered up the old sign with a wrap, essentially, and then put it back up.
Were there any lighting enhancements? Or
No,
was it just the sign?
just the sign.
Okay.
And again, sorry for the minutia, just to clarify, it's your perspective that the code violation is the size of the sign, nothing to do with like the design or
Size of the
language
sign.
on it or
Yeah.
anything like that? Gotcha.
That's-
I think we're good.
All right, thank you.
Anyone else from the city? Are we set there? Okay. At this time, I call the appellant to present their case.
Good morning, good morning.
Good morning. Please state your name and address for the record.
Jason Ross, 1927 South Church Street, Burlington, North Carolina, 27215.
Fantastic. And raise your right hand for me. Do you solemnly swear or affirm that the testimony you're about to give in this matter shall be the truth?
Yes.
All right. Please proceed.
I've got pictures if y'all want to see the pictures of before and after. If y'all want to look at them, it's the exact same sign, and you can still see the exact same this lettering is actually on this sign. You can still see it if you come down and take a look at it. But we were going by ordinance, maintenance of non-conforming signage. The signs were approved when I opened the dealership back in 2014. So in this one, it just says non-conforming signs may be repaired, re-lettered. You can do updates on your building, which we painted, so we had to take it down so we could paint. We didn't change anything, but the lettering. The exact same sign is in the exact same spot. We didn't do anything but just re-letter it and make the building look a whole lot better. That's the only thing that we did, which it says we can do.
So for my information, was it a white panel that you flipped around and painted the other side of, or did you paint over the panel that existed?
No, we took the panel down so we could paint the walls, re-lettered the panel while it was down, put the panel right back up with the same
Gotcha.
screws.
Okay.
So we didn't change anything but the color of the building and the lettering.
Has the property or business changed hands since the old sign to the new sign?
It has afterwards. I just sold the building 2 weeks ago. But the signage was already there. It was mine when we changed it.
The new sign was already up?
Yes.
Okay.
So it sounds like you did check code.
Got it right here. Yes, sir.
And your interpretation of the code is what you're relaying to us now.
Yes, sir. It says non-conforming signs may change copy in the form of replacement panels or replacement lettering, provided such change does not impact or reduces the degree of nonconformity. We didn't change any panels or anything. We just changed the lettering. It's the exact same panel.
Do you have anything else to present as far as that goes? That's the entire argument?
That was it. I mean, we didn't change anything but the lettering.
Okay.
I just want to clarify, appreciate your testimony, first of all.
Oh, yeah.
And so you're testifying as the owner of the property, but you described selling it as well?
I've sold it after this happened, yes, sir.
Okay.
I manage it now. I'm the general manager
Oh,
of it now.
okay. I was just wondering, you know.
Yeah, we sold out, and he
jurisdictionally or
hired us
whatnot.
right back in.
Okay.
Any other questions for Mr. Ross?
Is it your testimony that based on your understanding or you or Mr. Cantrell's understanding of the code that you guys felt a permit was not necessary in the manner that the city claims that one was?
The code clearly says non-structural repairs such as repainting or electrical repairs, incidental alterations which do not increase the degree or extent of non-conformation, and changing of copy as provided in the section. Then it says you can.
Yeah, I just want to, just.
I mean, that's what we were going by. We didn't change anything. We just cleaned it up and made it look better. Because when I put the signs up originally back in 2014, the city approved it.
Yeah.
And nothing's changed, just updated and freshened up.
Thank you. You can be
Can I
seated.
get those back?
Yes, yes, you may. Is there anyone else present who
Mr.
would
Chairman,
care?
excuse me,
Yeah.
I didn't know if the applicant, the appellant, wanted to have those items be a part of the record. I mean, if he takes the only copy, obviously.
I'll let you know. I've got more.
It sounds like it may be important to his case, and he would want them to be in the record. The clerk, I believe.
Thank you. Is there anyone else present who would care to offer evidence or statements relevant to this case? Looks like we have one. All right,
Chris
please state your
Marlin,
name
Chief
and
Code
address.
Enforcement Officer, City of Burlington.
Thank you kindly. And do you swear to tell the truth, swear or affirm that the testimony you're about to give in this matter shall be the truth?
Yes, sir, I do.
All right.
Mr. Ross is correct. That sign was permitted back in 2014 under old zoning regulations. In 2019, as most of you know, we created a unified development ordinance that brought forth a whole new set of changes. Signage was one of the big things that changed throughout that ordinance. And then one of the things that changed, brought in a different non-conforming sign section. And, Mr. Ross was looking at 9.5C, but one important line in 9.5C that you need to be made aware of is the very first line that says a non-conforming sign may remain in place and be maintained, subject to the following standards. Unfortunately, when Mr. Ross removed the sign from the wall, that took that condition out, moved it down to 9.6D1, which says that any non-conforming sign removed for any reason shall only be replaced with a sign that conforms to the Unified Development Ordinance. We have applied this throughout the city numerous times since 2019. And in order to be fair, when Matt brought this to my attention, history, we think about what we've done in the past to be fair and equitable to all businesses and residents within the city of Burlington. We try to, enforce all rules fairly across the board. Like I said, we've done this numerous times throughout the city on people that have removed signs, whether it be on the wall, on a pole, a monument, whatever it might be. We make sure that they come in conformance with the UDO once that is removed. And that's just where that decision was made. So I wanted to make sure that you understood that part of the maintenance section.
I've got a question for you. What is your definition of panel versus sign? Because that seems to be the area that is in contention here.
You're asking me my definition or what the standard definition in the Unified Development Ordinance may be? Because I don't have
Probably
that with me.
the definition in the Unified Code, I would say.
Yeah, I don't have that definition with me at the moment.
Was the frame still in place?
Officer Thomas, he saw that, yes, sir.
The frame was still in place.
There was a bracket, I believe, on the top and a bracket on the bottom, and the sign sits in between those two brackets. But from the city standpoint, the sign was removed, the advertising was removed from the building.
Questions?
And just help me with this
Yes, sir.
thought train right here. So I hear you loud and clear on the city's position that the sign was removed, and that impacted how the interpretations followed. And with regard to the city's recommendation about requesting a permit or what, that the city felt should have been done, is it fair to assume that, any permit for a future sign would not, would be constricted in size compared to the previously grandfathered in?
Yes,
sign
correct, yeah,
size?
yeah. Once that sign was removed, if he would have came and applied for a permit, once going through that process, if he wanted to put that exact one back up, it would have been explained to him that is now too large based on the width of the storefront of that building.
Thank you for that clarification.
At this time, I'll call on the appellant to offer rebuttal evidence or statements if desired.
I don't want to be repetitive, but we left the framage and everything up. All we did was updated the building. We can't paint behind the panel if the panel is there. It also says in that you can do electrical wiring. How can you do any kind of electrical if you don't remove the panel to get to the, we left the frames in place. All we did was took the panel down so we could paint behind it. In the pictures, you can see the new camera system where the wires go behind it. But all we did was just took the panel down, left all of the structure, the frame and everything there, and just updated the building. You can't do that with a panel in the way.
Thank you.
Mr. Ross,
Yes, sir.
2014, was this sign non-conforming at that time?
No, sir. The city approved the signs. Thank you.
All right. So we're going to, I believe, move into deliberations at this point. Evidentiary hearing can be closed or left open for clarifying questions during deliberations. I believe we've asked all the questions that we need to, so I don't mind closing it. If we close it, board members may not ask additional clarifying questions.
Well, I question that the existing sign in 2014 was conforming to the code at that time. So what was left on the wall? What is the frame of this thing that left up there? Was it a metal frame, top and bottom, 4 sides, or just 4 clips? That's a question right there. But as I understand, in 2014, the sign is conforming.
We'll have Mr. Ross approach and answer that.
Yes, sir. The framing is the size of the sign. It goes all the way across the top, all the way across the bottom. So when you put the panels flat on the front and it's bent on the top and the bottom so you can screw it. So the framing is the same size as the sign. And that was all left on the building. All we did was took the screws out and then took screws out the bottom and removed the panel, but the actual framage, it all remained in place.
As I understand from the previous testimony, there's just 4 clips left on the wall.
No, sir. It's a bracket that goes the width of the sign.
Mr. Ross,
Yes, ma'am.
did I understand that you did this all the way around the building and you have like signs all the way around the building?
The signs on both sides of the building are much smaller.
They conform to the code?
Yes, ma'am. The only thing we did was we took one sign that was on the front of the building. We had 2. We had the big one, then we had another one below it. To make it look better, we took the bottom one down and didn't even put it back up.
Thank you.
Yes, ma'am, thank you.
At this time, do I have a motion for the board to begin deliberations of this appeal request? Motion second?
Second.
All right. So we are, do I have a motion to close, to have the evidentiary hearing closed or open?
And is the motion going to be approved what?
Yes.
the
Well,
city's.
Yeah.
Since I'm kind of new, what is the deliberation? Do we talk about it?
So basically, yeah, we discuss it.
Okay. Is that, yeah, then I'd like to discuss.
Yeah, if we have, yeah, absolutely. If we have additional questions, we would keep this open. If we think we're all right, we'd close it.
Mr. Chairman, excuse me, just a procedural clarification, it is acceptable for the hearing to be closed, and if in the course of deliberations, after having closed the hearing, you can take a motion, you can receive a motion to reopen the hearing if that evolves, so it's not final that the hearing is closed, and there may not, under any circumstances, be
Thank you for that clarification.
a reopening
Yes.
of the hearing.
Might I ask one more question, Mr. Marlin, before we close? And again, sorry to be repetitive. In this language around change of signed copy, non-conforming signs may change copy, replacement lettering such as it doesn't impact a reduced degree of nonconformity. Is it your opinion or your understanding of the code that is specific to signs that are not removed?
Yes, sir. Are you talking under 1, maintenance actions?
Yes, sir, yeah.
Yes, sir. That's correct.
Okay, thank you.
All right, do I have a motion to close the evidentiary hearing?
Motion to close the evidentiary hearing.
All right, second?
Second.
All right. Let's deliberate.
What I'm struggling with is the wording. So I hear Mr. Ross saying frame, and the city's saying bracket, okay? So the question is and then the issue with sign versus panel, okay? And I guess I'm struggling with I don't know if there's a legal definition to be considered on what is a frame and what is a bracket, what is a panel and what is a sign.
I can tell you from a practical definition, the whole thing is the sign. When you're purchasing a sign, you can purchase replacement panels, you can purchase, new marketing, new advertising, but if you're purchasing a sign, you're purchasing the box unit, the brackets, the lighting, and the panel. So it's my opinion that the sign stayed up. I think this is a little ticky-tack. I think that in this case, Ross is probably in the right here, so.
Now, what would the correct motion to be to approve the city's notice of violation and the owner have to remove the sign?
Well, we need to deliberate whether the decision maker erred in the determination of this ordinance and whether the decision maker erred in determining whether a standard of this ordinance was met. That's what we're deliberating at the moment. As far as notice of appeal, we would grant the appeal if we agreed with Ross, or deny the appeal if we agreed with the city. Is that correct?
If you affirm the determination, the final administrative determination was that there was a violation. So if you affirm that, you are denying the appeal. The statute gives you the authority to modify the decision. You have the powers of the administrative officer according to the statute in terms of how you rule in this case. But a motion either to affirm the decision of the city or to deny the appeal would be effectively the same thing. You would be confirming or affirming the interpretation and the decision that there was a violation based on that interpretation.
And the flip side of that then?
Would be to grant the appeal, and you would be reversing the decision of the city that there was a violation. You'd be ruling that, according to your interpretation, there wasn't a violation.
If we, Mr. Attorney, Mr. Raspberry, if we were considering, as I heard the chairman, granting the appeal, would that determination require meeting those, I believe it's 5 standards regarding?
No, sir, this is an entirely different type of case. This is an appeal, and as you hear the appeal, you are charged with evaluating the facts in this case and also interpreting the law. In an administrative appeal type case, you have the powers of judge and jury in a court. So you could either focus on the factual elements that were discussed in the testimony, or you could look at subsection B, subsection C, and subsection D of the applicable code provisions and say this is the way we would construe any ambiguity or conflict we see in those code sections.
So staff told us that they were following this continuity that they had relayed throughout the city, that they had had this exact same thing happen and they removed signs by doing this. Are we to compare what they've done before to this, to say we should do the same thing to remain fair? Or is that outside of what we should be deliberating?
My opinion to you all is that you interpret the code provisions as you see them now as applied to the facts in this case.
I don't think that's outside the scope simply because this is a appeal as opposed to practice of the city by the UDO.
It appears to me that the main question here is, do we think the sign was removed or not? If so, then some of this stuff obviously kicks in. If we don't consider the sign to have been removed, then there's, and I guess I hear some of you guys mentioning this notion between brackets or panels were maintained. Would that mean that the sign was maintained since it in its entirety was not removed? I guess I'm just saying those things out loud, trying to understand if that's kind of the nature of the question we have before us.
The way that I'm looking at 9.5C in the first sentence, they use may remain in place instead of must. And then it goes on in section C2 to say that they're allowed to replace panels. And in order to do that, you would have to take down a panel to replace it. And that's what happened in this case. Similar to use the MS, how it would reverse the decision.
I appreciate that perspective. Thank you.
Let me ask this. If we've deliberated enough, do I have a motion to close the deliberations? Or do we still have more to talk about?
I move to close the deliberation.
All right. Do I have a second?
Second.
All right. Everyone in favor of closing the deliberations? Aye.
Create, let's understand the motion loud and clear here. What is the motion?
The motion is to stop talking about it and to vote on it.
Okay, so we don't have a motion to act, just
Correct.
close the discussion.
correct.
Okay, second.
Okay. All in favor? Aye. Opposed? All right. So the deliberations are closed. Now I'm going to ask for a motion for one of three things. Do I have a motion to affirm the decision of the code enforcement officer, a motion to modify the decision of the code enforcement officer, or a motion to reverse the decision of the code enforcement officer? And the first one is agreeing with the city. The third one is agreeing with the appellant. The middle one is something that we really haven't addressed.
What does the middle one entail?
Modifying the decision of the code enforcement officer would be to uphold their decision with caveats. In essence.
The third one would be,
Would be to agree with the appellant, to allow to grant the appeal, basically. To grant the appeal, to agree with Priority One Auto Sales and Mr. Ross to strike down the city's decision. So I'm going to need a motion for one of those three options.
I'm sorry.
No, you're good. Yep.
So number 2 is we agree with the city, but we could then allow them to continue with the sign the way it is?
I don't believe that's correct.
Mr. Chairman, just if I could clarify, I think you've correctly stated that according to the evidence you've heard, really the only 2 actions would be
First and third.
the first or
Yeah.
the third to reverse or modify. Sometimes, just not to confuse things, but if, for example, there were a zoning administrative enforcement had found several code sections violated, and you were to say, well, we think the first code section, yes, was violated, but the other 2 weren't. I mean, that's the kind of modification decision that your notes allow for, but they don't appear to be applicable to the facts or the evidence that's presented in this case.
I would agree. I'd say we haven't talked about the second one at all. And I don't think it applies here. I would agree with you. So let me simplify. Do I have a motion to affirm the decision of the code enforcement officer or a motion to reverse the decision of the code enforcement officer?
I make a motion to affirm the decision of the code enforcement officer.
To agree with the city?
To agree with the city.
Do I have a second on that? A second? Okay. Motion fails. Do I have a motion to reverse the decision from the code enforcement?
So move.
All right. Second on that? A second? All right. All in favor of reversing the decision of the code enforcement officer? Aye. All opposed? Okay. With a majority vote, the decision of the code enforcement officer has been reversed, and the sign can stay. All right. Moving on to item 6. Next on the agenda is subdivision variance 26-02.
Mr. Chairman, could we just pause just for a second
Sure.
to let me discuss something? Assistant City Attorney. That's Mr.
Exactly.
Mr. Chairman, discussing with Ms. Childress the composition of the board that was seated for the first case that you heard. I understand Mr. Grant is an alternate, and in fact, the panel of the board that were hearing the case and could vote on the case, make motions and vote, would have excluded Mr. Grant since he was the 6th member sitting as an alternate. the city has advised that they are not concerned, they would not consider an appeal of the decision, so the decision has been reversed, and that is fine as to this case. Going forward to the next case, we probably need to clear this up, and I'll take some responsibility for not, assessing this before we began, but we probably should make it clear that the composition of the panel hearing the next case would be the 5 members of the board, and unfortunately, Mr. Grant, typically alternates do remain. Typically, they don't participate, they don't make motions, but they are sitting as an alternate in case they happen to be needed. So as to the next case, it would probably be appropriate to make it clear in the record that the 5 members, excluding Mr. Grant, are composing the panel to hear this second case. As to the first case, with the city's statement of its position concerning the decision that you made, there will be no appeal. We'll process the decision in the ordinary fashion.
So to that extent, would Mr. Grant be allowed to ask questions or make motions, or would that be?
Typically not. Typically not, because at least in theory, an alternate member, even though the alternate may not be voting, could influence the decision-making process. So probably it's best practice not to have that.
So Mr. Cheek would have been in the same position too.
Well, I think the board needs 5 people, right?
Correct.
So I've been promoted from an alternate to on the board.
Is that the status now? Okay, I was not aware of that, but if that's the case, then yes, he would have, he'd be in the Trump position.
Would we, to that end, are you currently an alternate?
Yeah.
Okay, so to that end, would we bring in both alternates, or would we just bring an alternate in until we achieve quorum?
Mr. Chairman, our records show Mr. Check as a regular member.
Oh, am I? Oh, because this,
We have it down on paper as being a regular member, no longer an alternate.
Hey.
We just need to change your sign.
all right. Do I get a raise?
Enjoy that pay increase. All that PTO.
And that's noted in the previous month's notes that he's listed as a city member and not as an alternate. Yeah.
Okay.
All right, Mr. Chairman, would it be best if I just remove myself from up here for the next case then?
You're granted a seat on this council, but not the title of master. You can sit here, that's totally fine. You just can't vote or make motions. Is that fair? All right.
Mr. Chairman, may I ask Mr. Raspberry? We certainly appreciate the city's clarification on that. Is it your advice that it's not legally required for us to reassess or revote on this with the composed panel?
From a practical standpoint, I don't think it's an issue worth raising or that anyone would raise. The city is not going to raise the issue, and obviously the decision was to reverse the city administration's position.
Yeah.
So with the city attorney's office indicating as they have, I don't think it's worth calling Mr. Ross back and asking for a different individual to make the motion, because I don't think the vote count was going to be affected. It's just a procedural kind of thing.
Clarity.
No, we appreciate that clarification, though, for sure. Thank you. Are we good to move on?
Yes, sir.
All right, fantastic. Item 6 next on the agenda is subdivision variance 26-02. A concurring vote of 4/5 of the Board of Adjustment is necessary to grant a zoning or subdivision variance. As stated earlier, this hearing is a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how the board must make its decision. We have our attorney present, and he's been very helpful to assist if there are questions regarding the rules of procedure or other applicable law. And the board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record, and participation is limited. This meeting is open to the public. Everyone is welcome to attend. Parties with standing in the case, which involves a legal determination, have rights to participate fully. If any other individuals care to offer evidence relevant to the specific legal criteria for granting the variance, they will be permitted to testify. If you will be speaking, please avoid repetition. Focus on the facts and specific criteria set out in the city's ordinances, not personal preference or opinion. If the number of speakers is excessive or if testimony becomes repetitive, the chair reserves the right to limit remarks to those having legal standing under the law. All witnesses must be sworn or affirmed before testifying. Do any board members have any conflicts of interest for this appeal application? A legally impermissible conflict is defined by statute as a substantial family, business, or association or relationship with any party to this hearing. No. Alrighty, at this time I call on the planning department to present an overview of the case and formally enter the materials into the record.
Hello, once again, my name is Jeff McClintock, Principal Planner for the City of Burlington. I was previously sworn in the previous case. If you'll have patience with me, once again, I will read in the fact sheet for this particular variance request.
Just point of order, we don't need to swear him in again, correct?
I don't think so, as long as the record shows he's been previously
Same
sworn in.
meeting. Cool. Okay, thank you.
The case number is subdivision variance 26-02. Property owner is Titan Issuer Trust. The applicant, Ian Phillips. Location, 1428 South, North Carolina, 61 Highway, Whitsett, North Carolina, 27377. The Guilford County Tax Parcel Identification Number is 242219. The zoning is medium industrial, limited use. Ian Phillips received a sign permit, sign 26-047, issued for a ground sign at the south entrance. They are seeking a two-part variance request regarding additional signs for the property. Part 1, UDO Section 5.6, J5, ground signs, to request an additional ground sign at the second northern entrance when only one ground sign is allowed per single road frontage. Now note that in the previous zoning ordinance, there were no restrictions on the number of ground signs per road frontage. The number of ground signs was established at one per road frontage when the UDO was adopted in 2019. The second part of the variance request involves UDO Section 5.6 J13 wall signs. And that variance request is to request a wall sign that has a sign face area of 1,200 square feet when a maximum of 300 square feet is allowed on the primary wall facade. Enclosed in your packets, you'll find attachment 1, SmartGov variance application, attachment 2, the aerial map, attachment 3, the existing zoning, attachment 4, the future land use map, attachment 5, the UDO section 5.6 J13 wall signs, attachment 6, UDO section 5.6 J5 ground signs, attachment 7, UDO section 2.4 CC subdivision variance. Now, also enclosed, you'll find applicant supplied materials, attachment 1, a sign variance package, and attachment 2, the owner's signature page. And I'll be happy to answer any questions that I can.
I'm not sure this is a question for you or for the applicant, but currently the two signs are, I mean, how many signs are up now, one or two?
It's my understanding that no signs are up at this present time.
No signs are up. So
They-
these pictures are just renderings? Okay.
Yes. As of right now, they have received a sign permit for one ground sign, and this variance is to add onto that existing sign permit. because the standards that they're asking for, we could not approve the sign permit without coming to receive a variance.
I guess the question too is there's part 1 and 2. Are we voting separately on 1 and 2? Or are they collective?
I believe at the moment it's collective, but if we feel like modifying and having a third one, we can do that.
Chairman, I think we've in the speaker's notes, I think we've just suggested, and again, it's just a suggestion, that the evidence be received together, if you will, just for efficiency, but that the 2 requested variances be voted upon separately.
Mr. McClintock, just, this could be silly, and I know we wouldn't be here if it weren't jurisdictionally relevant, but is it, I'm just struck by the notion of a Guilford County tax parcel, a non-Burlington address, and then here we are, the city of Burlington, addressing these issues. If you could just give me any clarity on that.
Yeah, it's fully within our jurisdiction.
The extraterritorial
I
jurisdiction?
think that
No?
it's annexed.
Gotcha.
Yes.
Oh, okay, thank you for that clarity. I appreciate that.
Does the city have any contention with this request as stated?
The city's position is we were just not able to grant the request based on the standards in the Unified Development Ordinance. And this was their only avenue to get what they needed and to prove those standards that have to be met for a variance.
Thank you.
It's totally reasonable if you don't know this. I know that the number of ground signs you mentioned were adopted in the UDO in 2019.
Yes.
Part of the applicant's package references the Sheets Distribution Center as
Yes.
something that, in their opinion, thinks they would not be receiving special privilege, noting the more than one sign at that Sheets location. I was just curious, do we know if that Sheets was put up before 2019 or the last UDO?
It is my understanding it was put up before the UDO, and I do know that they have talked with us about those. The Sheets has talked with us about those signs and updating those signs. And I can't really, I don't think it would be appropriate to really speak about the Sheets location and their situation. But they may be before you requesting a variance in the future about some of the standards that now apply, because those signs would be non-conforming, being that there are 2 of them now.
Thank you very much for that.
Okay. So if I understood you correctly, for part 1, you said you didn't have the authority to grant or not, and that's why we're here.
Yes.
Are we talking part 2 now, or do we just focus on part 1 first and then discuss?
Well, we're
part
hearing
2?
it all together, and I'm assuming that answer is on both parts, is that correct?
It is.
Yeah.
It is.
It is on both parts?
It is. Under the UDO, we can only allow the wall sign standards that are in that UDO section. Some standards the applicant can apply for a variance, and sometimes an applicant will apply for a administrative adjustment if it falls within certain standards. This does not fall within those standards at all. So the ordinance has relief in it for things outside of the standards of the UDO, for signs and other numerical specifications, and that's why they're here. Yeah.
All right, so for part 2, the code is 300 square feet, and the
Yes.
request is for roughly under 1,200 square feet.
Yes.
What is your recommendation?
I'm not gonna, I don't think it would be appropriate to give a recommendation, neither for nor against. The ordinance allows them to come and provide their reasoning, why a variance would be acceptable, and you to.
So how did the ordinance determine 300 square feet is the maximum?
By the linear feet times 1.5.
Well, I mean, I know, but I mean,
Yeah.
why wasn't it 400 square feet or 600 square feet? I mean, why 300? Do you know the answer to that?
I don't, because I was not involved when they
When they made that decision.
When they made that decision. Typically, though, numbers like that in processes I have been involved with over in Greensboro, they're looked at by looking at many different ordinances throughout the state for other municipalities, and then a decision is made, and then it's approved by city council.
Any other questions for Mr. McClintock? You can be seated.
Okay.
Thank you. All right, this time I call on the applicant to present their case. And please state your name and address for the record.
Yeah, Jason Brandstetter, Tittman Construction, 9009 Coldwater Road, Fort Wayne, Indiana, 46814.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this matter shall be the truth?
Yes.
Please
Mr.
proceed.
Chairman, excuse me. This has been discussed a bit with the City Attorney's Office. Quasi-judicial hearings, there is a North Carolina State Bar opinion to the effect that when the applicant in a case of this is a business entity, that an attorney is required to present the case. I understand Mr. Phillips has a law license. Is that correct? Our expectation was that you were going to be represented by an attorney because that's what the State Bar opinion has expressed, that these proceedings are like court proceedings and presenting a case is the practice of law. If you don't have an attorney to represent you, one workaround, one suggestion I might make is if you would acknowledge that you are appearing as a fact witness only and you're not making a case in terms of summarizing your arguments and calling witnesses and cross-examining witnesses and so forth. If you're simply here to answer questions and to testify as to matters of fact and you acknowledge that you're a fact witness, that is fine. Otherwise, if you have an attorney present, sometimes an attorney just simply says, I'm the attorney, I'm here representing, and then backs off and the witnesses appear as fact witnesses. But I know it's annoying as it can be, but there's a State Bar opinion that puts a responsibility on me to advise that there is this ruling that appearing to present a case and to make arguments is unauthorized practice of law. So that's the point. If you have an attorney present, it'd be helpful. If not, then if you would acknowledge for the record that you're appearing only as a fact witness, that would probably cover the basis. But I have to make this annoying disclosure to you because the State Bar requires it of me.
I appreciate that. Can I talk with my...
Certainly, of course.
Would the decisions be negatively impacted by not having an attorney present?
No, sir.
Okay.
It simply is a requirement of the State Bar, a ruling of the State Bar, and I'm just required to make that disclosure of you.
So
I mean, at least
someone could then challenge the ruling?
No, sir.
Okay.
No, sir. The issue is whether there is an unauthorized practice of law going on, and there is that State Bar opinion.
Sure.
The practical effect of this is probably not significant, but
sure.
I'm required to make the disclosure.
No,
Some cities have a rule that if there's a business entity that's involved as property owner of the applicant, a lawyer has to appear.
Okay.
Smaller municipalities, it's just not practical, but that's where we are.
Sure. Okay, then I believe we are comfortable moving forward as witness only.
Thank you, sir.
Thank you, Mr. McClintock, for that introduction. Good morning. As I said, my name is Jason Brandstetter. I represent Tittman Construction. We are the design builder of this project. Today with me is Carter Eifert, a colleague, and Mr. Steven Da Silva, who represents ADUSA Ahold Distribution. If you don't know about the project, I wanted to just briefly describe this project to you. It is 1.2 million square foot. Most of the building is 90 foot tall. It is developed on 192 acres. So the project in scale and size is substantial, probably something that most of you have not seen. When it is completed, it will be one of the largest, most state-of-the-art distribution centers in the country. It's a $900 million investment. It is highly automated, and there's very few of these in the country. The automation is done by a German company called Witron, and they'll be sending crates of automation over here as we build the building. That being said, the first exhibit for you is a site plan of the project. Once again, it is developed on 192 acres. There are two main entrances to this, and that's going to be one of the main focuses on. So there was a lot of logistics planning around something this large when you're doing 600, 700, 800 trucks a day for distribution out to Ahold distribution stores. We separate the truck entrance from the main employee entrance. Obviously, we never want those from a site safety standpoint to cross. Those curb cuts, per se, are 1,136 feet apart from each other. Once again, the site is enormous compared to most industrial sites. We are requesting to add a monument sign to the employee entrance. As was stated, we do have a monument sign approved for the truck entrance. It was Ahold, when they designed this building, you're going to see some renderings as you get into the exhibits. They want to create a campus look. So even signage to match what the building's going to look like for their employees, for people visiting a $900 million facility. It is really prudent that a second monument sign address not only architectural, but the safety of the site, the signage coming down the road. Everyone's going to be coming from the east side, and so it was strategic that the truck entrance would be first. And we got a large sign there that hopefully makes sure they don't pass it, because on this road, if you pass it, I don't know if you're familiar with the road, it's kind of more of a country road. There's really nowhere a truck's going to be able to go down and turn around and come back. So we got to catch the trucks immediately at that first entrance. The second entrance is the employee entrance. You can see they will be labeled associate. We did originally do a talk about these monument signs in the past. We had them actually larger. We did go back with feedback from planning, and we did reduce the size of these so that they are at least under the 150 square foot requirement. So each sign does meet that criteria. It's interesting, though, I studied the sign ordinance, and other than the separation of property lines, you know, if this was divided into multiple property lines, I could put these signs every 50 feet. Every 50 feet, I could have another monument sign if I just struck some property lines along there. That is what your signage ordinance allows. We're simply asking for two signs separated by 1,100 feet, lineal feet of building. That do meet your criteria.
So these signs are compliant. The only issue
They are
is-
compliant, it's the number. Your ordinance says one sign per property. I don't think when an ordinance is written, it thinks that one property is 196 acres. You know, and that's unique. That is what is unique about this project, is the relative size, and we're going to talk about that a lot. This is an enormous project.
In the assembly of this project, it appears that there have been houses on this, this land before. You
Yes.
purchased several parcels and combined them?
12 parcels were purchased and combined into one, and then replatted.
So in your application, you mention visitor and employee entrance, but on your sign, you only have associate entrance.
Oh, I'm sorry, the visitor employee would be the same entrance,
Okay,
and then
but-
the truck is the other
Right,
entrance.
but why wouldn't you put, in addition to associate entrance, put visitor as well, so that visitors know what entrance?
Is the rendering?
Those are just renderings and probably.
Yeah, they're just renderings right now, and that might change. Associate visitor, I guess that would be an Ahold decision in the next, how they want to do that. These were simple renderings that we were trying to portray of what this sign would ultimately look like. Great question. 1100 part, it meets size. I think we've talked a lot about that on the monument signs. Part 2 is the building sign. And so, yeah, so here are the renderings of each sign and what they'll consist of, the materials. Could we go to then the renderings of the building? This was, and this can be ignored, we looked around, it's sheets, it's a larger development that had the same sort of layout, a truck entrance and an associated entrance, and they did do 2 signs there. It sounds like it doesn't apply because it was done before the new ordinance, but we did just want to enter that in as that was another large development that had the same sort of.
How many, it looks like there's multiple buildings. Is that what I'm seeing here?
That's one building.
It's
one distribution center. It's just in an L shape.
Yeah, that's the Sheets Distribution Center.
Oh, okay.
That's just an example of something close that similar, maybe similar in size, similar in linear frontage of road, that they did actually do 2 monument signs for the 2 separate entrances. But if you could keep scrolling. So now I want to talk about the building sign. So the facade, so a couple things. We are only asking for 1 building sign. The code allows for us to put a building sign on all 4 sides if we wanted to. 4 sides, 300 square foot each. We are actually only asking for 1 building sign that faces the main road, which would be the south portion of the building.
And how did you determine the size, the square footage of the sign?
Yeah, so based on some visual representations from the road, so a couple things about this building that I haven't mentioned yet. It sits 950 feet off the road, so it's pushed way back off the road. The lineage square foot, the lineal footage of that south facade is 1,400 lineal feet. So if I could apply your 1.5 square foot to that lineal foot, what I'm asking for falls way below what I would be allowed to do. The issue becomes is you've capped it at 300 square feet, which I think for most buildings, I mean, you got to think about when you're talking about industrial buildings, you could be talking about a 20,000 square foot building or a 1.2 million square foot building. It's different. A 300 square foot sign on a 20,000 square foot building makes a lot of sense. A 300 square foot sign on 1.2 million square feet doesn't, especially when it's 90 foot tall. We're standing at the road here. I did some architectural renderings. The sign that we're talking about is on the right-hand side. Thank you for pointing that out. Right there. That represents 300 square feet. And you can see from the road, it is almost not legible at 300 square foot. If you could go to the next rendering from that same perspective, that is the 1,200 square foot, which once again, for the lineal length of that building, scale proportion seems to work. It is now legible from the road. Remember, I'm 950 feet away from that road. And we think it just fits it better. Now people are going to see it from the road as they drive by. And once again, I think you can look at it multiple ways. 1 sign we're only asking for, not 4. The size, scope, of scale of the building is much different and unique than the others. And then the distance from the road, we've set this building back so far, makes a big impact on what that wall sign can do. That concludes my presentation. We are here to address any questions you may have, and thank you for your time.
It's a fascinating site, and there's all sorts of questions that I have that are beyond the scope of what we're addressing today. So I will refrain from asking those, and I'll remind the board as well about suitability of the site, distance from the highway, all sorts of questions like that. We don't care about it. All we're looking at is the signs, the number, and the size thereof.
I did forget to mention, I do have direct measurements that constitute the 1,200 square foot. So you can see the overall height and length of that.
Is
sign.
that section of the building 90 feet tall? You said the majority of it
That
is?
section, no, that section is 35 foot tall.
And I'm looking at the rendering,
Yeah.
you know, just from a perspective standpoint, from a placement standpoint, is that a fire escape on the left there, just past the fountain?
Yeah, that is a stair accessing the higher roof,
And
yes.
is that why the sign couldn't go on the taller part of the building? Or is it, I'm just trying to
That
figure out.
taller part is set way back even further. So
Okay.
that's set back probably 1,500 feet. We had debated that with Aho for a long time to actually try to get it up higher, but it's set so far back, I would actually even have to make it bigger.
Gotcha, okay.
It's a
Is there
great
any way
question.
to blow that up so I can see it better?
You should be able to zoom in there. So close.
Just out of curiosity, what's the estimated completion date for the project? I drove by yesterday, I recognized you got in the
Yeah,
beginning.
we're moving a
phase.
lot of dirt right now.
Yeah.
So yeah, we're still in development. Steve, officially, 2029 will be official opening.
With regard to the front facing of the building and the current, are there intentions to bring the ground down lower than it currently is setting?
We are going to sit up from the road.
okay.
Yeah, you
Gotta
will
keep that.
incline up.
Okay.
Balancing 196 acres pretty tough. I think it was 50 feet from one point to the other, so we're trying to find somewhere in between.
And the current entrance into the facility where trucks in the construction are entering, that is the proposed associate entrance?
Yes, yes, sir.
I would assume, excuse me.
Go for it.
I would assume that for both entrances, you would have those maintained for emergency entrances, for fire, police.
Yeah,
or
yeah,
whatever.
there are 2 entrances required because of the size of the building by the fire department, yes.
The signage on the building. What's I'm struggling to see the real, I guess, necessity of such a size increase. Or, I mean, potentially even signage itself, because you've got hopefully the 2 road signs, right? Can you speak a little bit to that?
We think the building signage you're actually going to see the building signage more than the monument signs. The monument signs are as you drive up on it, it's going to be more directional. This is the company, this is as I drive by, this is who we are, what we are. They're going to be very proud of this building. I think 1,200 square foot, it represents 1.7% of the facade. So when you look at it, it's an incredible small amount of the facade that we're talking about. You're allowed a building sign. I mean, if you drive around, most people will put up a building sign. It's an indication of their company, and they want the public to see it. They want the public to drive by and say, wow, that's ADA USA, and they develop in Burlington. It's more just about the size and scale. I think you definitely have to relate it to the scale of the building, because it is a big increase from 300 to 1,200 square feet. We'll definitely admit that. But as we did that study and we did multiple perspectives, it took us to really become legible from the street. It took about that size to be able to read it.
Can you maybe elaborate more on that process?
Yeah, so if you go back to like the 300, so we did this all in 3D. If you could go back to the 300, you can see there, unless I zoom in, and still as I zoom in, you really can't read it. So then we went to 600. Okay, what does 600 look like? And in hindsight, I wish I would have shown you all of them. But it took to 1,200 square feet to really become legible. And that view is from an eye perspective, so that's a 50 millimeter. If you know anything about camera or the eye views, 50 millimeter is basically what you see standing there, and that's what that's rendered at using a 50 millimeter camera in the 3D program.
questions? Thank you.
Thank you.
Yeah. Is there anyone else present who would care to offer evidence of statements relevant to this case? All right. Are we good to close for deliberations?
I look to close for deliberations.
All right, all in favor? Aye. All right. We are, at this time, we're closed for deliberations. What do we think? Well, we can talk about each part separately if that works. We can talk about the road sign first, or road signs first, and then the building sign second, if that, we'll keep it streamlined.
All right. My background is in supply chain, and I visit global suppliers everywhere. And most places that I've visited have two signs, one for truck entrance, one for employees and visitors. And I always look for the visitor sign because I'm the visitor. So I looked at the aesthetics of these signs. I think these were very good renderings. So I think that, it's appropriate to accept it.
And let me give a little bit of framework here also, because it's not just an opinion-based thing. We have to deliberate based on this one's the 5 hardships. Unnecessary hardship would result from the strict application of the ordinance. The hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardship did not result from actions taken by the applicant or the landowner. The variance approval is the minimum necessary to make possible the reasonable use of land, building, or structure, and the requested variance is consistent with the spirit, purpose, and intent of the ordinance. That's what we're wanting to, if we approve this, we need to make sure that those are met. And if we disallow it, it needs to be based on those standards, which we also have somewhere in the packet, if you need to reference them. Yeah. And from the road signs, I would agree that unnecessary hardship would result from the strict application of the ordinance. From a safety standpoint, big trucks turning, I believe you said 600 or 700 trucks a day. Road conditions aside, having two signs I think would make a ton of sense as far as that goes. Location, size, or topography. I do have one question. I'd like to open this back up if the board is all right.
I'll make a motion to reopen evidentiary inquiry.
Second. All in favor? Yes. All right. Setback on the building. You mentioned that it is 958 feet, and you can approach if you want to.
Yes.
958 feet. As far as, requirements from City of Burlington, Guilford County, Whitsett, North Carolina, all the important bodies. Why is the setback as it is? Is that
Several things. So the topography, we sit higher than the road, and I need to bring those trucks up pretty gently because they are stopping, waiting to get through the guardhouse. So I wanted to limit that to about 2% grade, maybe 3% max, and that made us push it back. It was really all about topography. And then growth. So this building is planned growth. The employee parking lot would expand to the south, closer to the road in the future, and truck lanes could be more in the future too.
Thank you.
Yeah, thank you.
Anyone else have any follow-ups on that? I need a motion to close again.
I'll second.
All right, all in favor of reclosing for deliberations? Aye. Aye. All right. All right, closed again. So, Yeah, that was, my big question was what, is this hardship because they just put the building back too far, but there's a valid reason for that. Which I don't think is, is specific to the landowner. I think it's specific to the requirements of the business and space, so. Minimum necessary, they're not asking for 18 signs. They're asking for 2, 1 for each road. Seems to follow. Consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured, substantial justice is achieved. We feel that that's.
That's more convenient for others that they have to go by. If they go by once, because they miss it.
So we're not voting yet, but we're going to set aside the road sign portion of this and go to the building sign. Is that acceptable for everyone? All right. So the building sign, we have, it's going to sound really familiar, the same 5 requirements. Unnecessary hardship would result from the strict application of the ordinance. The hardship results from conditions that are peculiar to the property, such as location, size, or topography. The hardship did not result from actions taken by the applicant or landowner. The variance approval is the minimum necessary to make possible the reasonable use of the land, building, or structure, and the requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured, substantial justice is achieved. How are we feeling about the building sign when it comes to this?
I certainly recognize the applicant's notion that it's just about 1.7% of the building base itself. I'd certainly be curious how that compares to this typical 300-foot standard for other size businesses, but that's not necessary per se. Well.
Did you, can I see the criteria that you read? Got it right there. Starting here and going on to the next page. Okay. We do have it in our packet as well.
Yeah, I was looking for it.
I know. It's a big packet.
Yeah.
You know, there's this language of the variance approval is the, quote, minimum necessary to make possible reasonable use. I know that's, that quote, determining that minimum necessary is
I think
a little fickle for me.
I would say it's fickle. I think you demonstrate it fairly well that, you know, with these 2 side-by-side photos,
Yeah.
300 feet, you can't read 1,200 feet. You at least get an idea what it is. So I would say that would be at least a fair application there. But my question is it necessary?
I think sign 1 option is the need. I think sign 2 option is a lot.
There we go.
That's not true.
So you're saying the building sign is more of a want than a need, correct?
Right.
I would agree slightly on that. I think the unnecessary hardship for the ground signage is definitely there with traffic safety. But I also think they have an unnecessary hardship with the main sign. Just making sure that it's similar to the other businesses, so that they can get the business name out there so people can see it. And it is peculiar to the property's size and location and topography. And I think in order for them to have a reasonable use of a sign, they would need this variance. It would be the minimum required.
And then I think the fifth part of this is important to apply to the first. The requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured, substantial justice is achieved. We are talking about a very large building with what would otherwise be a very small sign, right? I don't think that has too much to do with safety, but it might have something to do with justice when we're talking about equality, fairness, what have you.
I mean, maybe this is a stretch for safety, but, you know, if a person is looking for the building, yeah, 300, they definitely wouldn't see it. And if they're straining to look at the sign on the building while they're driving, that could cause an unsafe condition. You know, and I appreciate the reasoning of why it's 1,200, because it seems like, I was thinking 1,200 seemed like we were just too large based on the picture and the document. But it sounds like there was some analysis done to determine that it should be 1,200.
All right.
And, you know, I'll just note in the applicant, page 2 of their application, they, in regards to the wall sign, note that it's because of this topography situation. And their contention is that it's limited to the amount necessary to create legible identification here.
So as far as deliberations go, do I have a motion to close deliberations? And what we're going to do is, after we close deliberations, we're going to vote on the ground signs, and then we're going to hold a separate vote on the building signs. So you guys know the structure of what we're looking at here. So do I have a motion to close deliberations?
I'll second.
All right. Everyone good for closing deliberations? Aye. All right. Deliberations are closed. Now, flipped page too soon. Do I have a motion to approve the variance for an additional ground sign?
I make the motion to approve.
Second that motion. All right. Then all in favor of approving the variance for an additional ground sign? Aye. All right. The variance is granted to allow an additional ground sign. Do I have a motion to approve the variance for the size of the wall sign to be up to 1,200 square feet?
Make a motion.
Motion, do I have a second?
I'll second.
Seconded, all right. Then all in favor of the, to approve the variance for the size of the wall sign to be up to 1,200 square feet? Aye. All opposed? The variance is granted to allow a wall sign of up to 1,200 square feet. All right. Thank you. We're moving on to item 7. We're almost done, folks. Is there any new business for the board? No? If there's no other business, can I get a motion to adjourn?
I'll make such a motion to adjourn.
And we got a second. All right, everyone in favor of adjourning? Aye.